Hello and welcome to Legal Minutes. Today we're going to be talking about probably one of the most common categories of questions we get on the legal hotline, and that's about disclosure, when you should disclose and how you should disclose in a residential property sale. I'm joined today by Betsy Urbance, Director of Legal Services for Illinois Realtors. So Betsy, let's talk about this. When should you disclose?
When should you disclose, or what are the basic requirements for disclosure in Illinois? Basically, the general rule to keep in mind as a real estate licensee is that any known, latent, physical, material defects in the property need to be disclosed if you're on the seller side of the transaction. And if you're on the buyer side of the transaction and you have actual knowledge about a defective condition like I described, you would want to share that just as a common law duty and as an agency duty with your own clients. So that's the very, very basic and general overview.
So Betsy, what forms would be necessary in order to make sure that you're covering yourself from a disclosure standpoint?
Right, John, to meet the requirements that we just talked about as far as the general overview, there are, I call them the big three forms. 2 are state required forms under their own statutory authorities, and 1 is a federal statute. The federal statute is lead-based paint, and the disclosure, I think you've got to be under a rock not to be aware that lead-based paint disclosure is required, both the form and a federally produced pamphlet, if the property is a residential dwelling unit or contains any residential dwelling units that were built before 1978. The other 2 are the residential real property disclosure form, which I often refer to just for sake of brevity is the seller disclosure form, and then also the radon awareness form. Those are what I call the big 3.
Now I noticed among those forms you didn't include any type of a mold disclosure form.
I did not refer to mold disclosure form because mold disclosure is not, a form for mold disclosure is not a requirement under any statutory authority. So the Illinois Realtors, based on advice from its legal team, made the decision to discontinue forms that were produced, way back when mold was the issue du jour and folks seemed to be demanding some sort of form. But the science really hasn't developed to give us any exact measurable standard that affects everybody the same way.
So are there any exceptions to disclosure, Betsy?
There are some exceptions to the disclosure under the 3 statutes that we've just talked about. Under lead-based paint, I will say there's very few exceptions. In fact, the question I often get on the hotline with regard to lead-based paint is if someone bought the property back that had been in foreclosure. So let's say the lender bought the property back or took the property back in foreclosure. That lender, when it resells the property, if it's pre-1978 property, would owe the lead-based paint disclosure as well as that federal pamphlet. And that's something that I think might be often overlooked. Now, there are more exceptions under seller disclosure and under the radon awareness. They're similar. They're not exactly the same. I'll give you a few examples of the exceptions under both seller disclosure and radon awareness. Those include transfers pursuant to a court order, transfers from a mortgagee or a mortgagor, and so that would be a situation where when the lender took back in foreclosure and is reselling, they would not have to provide the seller disclosure or the radon awareness form. Interfamilial transfers, government transfers to and from a government entity would not require seller disclosure or radon awareness. There is an exception under seller disclosure if it's brand new construction and it's never been occupied, then under that scenario, a seller would not owe the seller disclosure form. Under radon awareness, there's no similar exception for new construction, so radon awareness disclosure would be required. Yeah.
So Betsy, what if you have an absentee owner? What happens then?
All right, if you have an absentee owner, and I get this question quite a lot on the hotline, especially under the seller disclosure form, if you have an absentee owner who has not lived in the property, that owner still has an obligation to complete the entire seller disclosure form to the best of his or her actual knowledge, even if the answer to question number 1 on the form, which is, have you lived in the property in the last 12 months, is no. So even if the answer to question number 1 is no, the absentee owner still has an obligation to complete the form fully to the best of his or her actual knowledge.
Well, thank you, Betsy. We're joined here today by Betsy Urbance, Director of Legal Services for Illinois Realtors. And Betsy has been walking us through some of the disclosure issues that could come up in a property transaction. We have plenty of forms at illinoisrealtors.org for our members, so please feel free to visit there and check them out and download them as part of your member benefits.